So what's going to happen is basically that Matthew or Matt, who's a partner from HaynesBoone, will do a 45-minute presentation, and then we'll have a 15-minute Q&A after Matt's presentation.
Hey, Eleanor, it's Matt. Can you see my slides?
Yes, I can. I think everybody can see your slides. We're going to wait until 12:05 for people to join in. Hopefully, Gisela can share the introduction slide that we made. If not, you know what? Life happens and we'll go directly. If it doesn't happen, then we'll go directly into your slides.
Sounds great.
Yes, Matt, in order to share the first slides for introduction, can you stop sharing your screen, and then we'll go back onto sharing your screen?
Yep, no problem.
Thank you. There you go. Awesome, Gisela. Thank you so much.
No problem. So you should be good to go now.
Yeah. I'll wait 1 more minute and then we'll go. Then we'll kick it off. I hope everybody is staying safe. I hope everybody's well. And I hope everybody, in my situation, I'm actually a school teacher as well. So it's not the easiest thing, but I hope everybody is holding up fine. All right, we'll start in 1 minute. That's 16 participants currently. All right, we'll kick it off. Thank you so much, guys, for joining. We will have a webinar today on the employment law experts, a webinar really how to navigate change required by the new laws. So this presentation will be done by Matthew Deffebach, who's a partner at HaynesBoone, and who will basically cover SBA, the SBA loans and Paycheck, I believe the PPP. Also, we'll cover the CARES Act. And I believe as well, if I'm not mistaken, the unemployment, the state resource, which is the through the Texas Workforce Commission, which is basically the unemployment check. Then Matt, you can kick it off. Basically, don't hesitate
Great.
to share your screen, and we can see your slides.
Great, Eleanor. Okay. All right, so as Eleanor said, I hope everyone is staying safe, and obviously these are interesting times for sure, and they definitely implicate a lot of employment issues. And so my focus is labor and employment. I've been helping companies for over 23 years now on employment issues. I want to just kind of kick in and talk about really what some of the main kind of issues are. Slide's frozen, so as I kind of fix this, 1 second, bear with me. Okay, sorry about that. Of course, we're all dealing with new technical changes and challenges, right? And freezing slide decks is now one of them, so hold on. Okay, we'll probably just have to do it this way. All right, so as we jump in, I really wanted to talk about a couple of things. CARES Act, obviously, which deals with small business and other loans, unemployment insurance assistance as well. And we'll kind of start there because this is all, breaking news from the implementation of the act. And one of the things for everyone to keep in mind is there's still going to be guidance. There's a lot of questions that are unanswered, and we are going to get guidance from government within the next 30 days that may fill in some of the gaps. So as we talk about the small business loans, the Paycheck Protection Program, the first thing is to consider, is your business eligible? And as you can see, if you are a for-profit company, or if you're a 501c3 nonprofit or a 501c19 veteran organization, if you employ less than 500 employees, that's full-time, part-time, includes any affiliated entities, or you meet what's called the SBA size standard for your industry, and that information is generally available on the SBA website, then you would be covered by the PPP. The other available relief is for those businesses with multiple locations, particularly if you are in the accommodation and food service industry, so hotels and restaurants, as long as your single location employs no more than 500 employees. So that's a way to also wrap in, smaller entities that might have more employees, but are spread out over smaller locations. And then also anyone who's an independent contractor, sole proprietor, self-employed individual are all covered. What is required? Really not a lot. You have to be able to certify in good faith that the loan is necessary due to the current economic conditions caused by COVID-19, and that you're going to be using the funds to retain workers and maintain payroll and other payments that are necessary, obviously your lease, utility. And then the only other part is that you're not receiving duplicative funds from another SBA program. How much are you eligible for? It's the lesser of either 250% of your average monthly payroll costs, and that's looked at over a 12-month period, or 10 million. So, 10 million is the cap for these loans. Could be less based on when you look at your overall payroll. So that's what the eligibility requirements are and the amounts. What can you use these loans for? As you can see, allowable uses are for things like payroll, the costs associated with the benefit plans, anything that would be salary, commissions, and then those things that are necessary to keep the roof over the head of the employees, interest on your mortgage, rent, utility, and any interest on any debt obligations that were occurred before February 15th of this year. What's very important to a lot of folks to make sure if you're interested in trying to obtain one of these loans is you can obtain loan forgiveness when you use it for these things such as payroll and taking care of potential workers. The key to that is twofold. One, for loan forgiveness to be applied, you have to either maintain your workforce numbers and payroll. You cannot be reducing your employees or reducing your payroll. But realizing that may be what a lot of businesses will have to do, as long as you basically take your business back to the levels that they were at. So if you do have a layoff, or you do reduce income, as long as you bring those levels back up by June 30th, 2020, which is the end period of the loan, then you still be eligible for loan forgiveness. So that might allow some companies that simply cannot maintain current levels of payroll to reduce, obviously secure the loan, and then rehire to those numbers by June 30th to get loan forgiveness. That's a very important provision and part of what you want to look to in planning. These loans are unsecured. You do not have to have a personal guarantee, and they're totally backed by the U.S. government. So the next portion that we're going to talk about, in addition to the small business loans under PPP, is unemployment. Unemployment strategies for small businesses, particularly trying to help their employees, is a very important strategy currently in COVID-19. One of the things is you sort of look through your options and are planning around whether it's obtaining a small loan or just reducing costs, is to think about initially, can you maintain some level of your workforce, but reducing hours? And the Texas Workforce Commission has a shared work program that basically would allow you to reduce your wages between 10 to 40% along different units within your business. So it doesn't have to be across the whole company. And in doing that, the TWC would then make up that 10 to 40% offset with unemployment. And so that's just a generally good strategy to consider. But there will certainly be businesses that will just simply not be able to keep even a reduced payroll workforce. And that leads to options such as furloughing employees. Under some of the current changes under CARES Act and also just by the Texas Workforce Commission here in Texas, furloughed employees are going to be subject to unemployment. And so that's obviously another way if you want to try to avoid complete layoff, potentially by keeping employees on the payroll for health insurance, or just to avoid the process of terminating and having to be hired later. Furloughed employees who are not working will be subject to unemployment. So let's talk a little bit about how CARES further enhances the available unemployment benefits for your employees. One of the big provisions is that it expands eligibility. So as you all know who've dealt with unemployment claims, generally there's only certain triggers that allow an employee to get unemployment. Those have been greatly expanded. So workers that typically, like independent contractors, those who are self-employed, those who have a short work history, things that would typically exclude employees, those barriers are gone. So generally, if there's an impact based on COVID-19, the idea is that a worker will be eligible for unemployment. CARES extends what is normally the state limitation of 26 weeks to 39 weeks. And that's important because there may be employees who are getting a double whammy of having been unemployed already and already burned out part of their state unemployment, but now they would get an additional 13 weeks. So the amount of coverage is much longer. Under CARES, the enhanced unemployment ends December 31st of this year. And by far, one of the biggest benefits is that the current state law amount, which in Texas is typically capped at around $525 a week, now the federal government is enhancing that $600 per week up to 4 months. So they get both the state unemployment and they get the federal enhanced $600 a week on top of that. The other thing that you may be aware of is typically for unemployment, someone has to have been unemployed for a week before they can obtain benefits. That 1 week waiting period has been waived. So pretty expansive changes in terms of the unemployment and working with your workforce to try to use unemployment, whether for offset of furlough, using it to decrease your payroll and your hours work, and just a way to potentially also work with the small business loan if you need to reduce your workforce, but then bring them back in order to be eligible for that loan forgiveness provision. So those are really kind of the very high level to deal with CARES as it relates to small business loans and unemployment insurance. The other major law that we're going to shift our focus to is the Families First Coronavirus Response Act, the FFCRA. That is a law that is providing paid leave and also enhanced leave for those who have child care situations that are impacted due to COVID-19. So this is a law that also we're starting to get some guidance from the Department of Labor. And if you have questions, you can see that they have a pretty lengthy FAQ that's now that they continue to actually supplement or changes to it. It looked like this morning, actually, when I took a look at it. And so we're getting a little bit more in terms of answers on Families First as compared to CARES, but that's because Families First was actually passed almost 2 weeks ago. So the guidance has come out, but we're still waiting for some of the guidance on the CARES Act. So on Families First, here are the kind of important initial things for everyone to consider. This law is about to become effective on April 1st. It will apply between April 1st and December 31st, and it applies to employers with fewer than 500 employees. So many large employers are excluded. If you have fewer than 500 employees, again, including full-time, part-time workers, anywhere in the state, DC, any territory or possession of the United States, then this law applies to you. So given that a lot of small businesses are impacted by Families First, there are a lot of very important provisions and some helpful guidance from the Department of Labor when you think about the effect of this law on the nature of your business. So first, we're going to talk in kind of two big buckets about the FFCRA, the paid sick leave mandate, and then the Expanded Family Medical Leave Act. And so if you've dealt with employment issues and if you have sufficient numbers to have been covered by the FMLA, the Family Medical Leave Act, you're going to be familiar with some of that. And you'll see here on a slide in a second, what's very important is that that FMLA provision under this law now applies to employers that typically would have been exempted from the FMLA because they were small, smaller employers that didn't have enough employees. Those employers are covered under this new provision of the FMLA. So there's been a lot of confusion about that and confusion about whether all of the FMLA has been changed. And so we'll spend some time to hopefully clear up a little bit of the sort of muddiness that's surrounded this law, particularly with its revisions to Family Medical Leave Act. So as we get into this, we're going to start with the paid sick leave. And I think it's important because we do have, small entities that are participating, that there are exceptions to this law. One is for employers of healthcare providers or emergency responders. They can be excluded from both the paid leave and the revised Family Medical Leave Act. And then also, and this one is, I think will be important for people to review, is if you have fewer than 50 employees, then if you can make a case for why complying with this law, having to pay the leave, whether it's under paid sick leave or paid FMLA leave, then if you can show that it would jeopardize your business, what they call legally as a going concern, then you can potentially be exempted from it. We are waiting for guidance on this. Currently, the Department of Labor has said you need to document why your business, one, has less than 50 employees, including part-time, and then try to explain why the cost would jeopardize your business. And keep in mind that in doing that, the paid sick leave provisions of this law and the FMLA paid leave, employers are basically getting a refund on what they pay through a tax credit. So you have to effectively show that the short term, before you could get your tax on refund, would basically be too detrimental for you to comply. So we're looking for the DOL guidance on this. One thing you'll note, the Department of Labor says, don't send us your case for why you should be exempted. So it sounds like it's going to be a self-policing type of issue currently, but we'll get some more guidance on that. Okay, so let's talk a little bit about what are the paid sick leave requirements. So what does an employer have to do under this law? You have to provide 2 weeks of paid sick leave at the employer's regular rate. So, if they're an hourly employee, it's whatever that hourly regular rate would be. If they're an exempt employee, then you need to determine what would be the equivalent in terms of the amount that's paid based on their exempt status. And here's the really important part. The leave is to be paid if the employee is unable to work or telework. And so, you want to think through that, because obviously if there's a situation where the employee is able to telework, then they're not eligible for the leave. And the DOL has recently defined a little bit about how do you make that call on whether someone is unable to, particularly telework, where a lot of offices now, are closed that are not essential businesses under the shelter-in-place orders. So if an employee is unable to work or telework for the following 3 reasons, they get 2 weeks of paid sick leave. 1, they're subject to a federal, state, or local quarantine or isolation order, which would include the Harris County and surrounding county shelter-in-place orders because of COVID-19. They have a healthcare provider who has told them they should self-quarantine related to COVID-19, or they're experiencing COVID-19 symptoms and they're trying to obtain a medical diagnosis, which as we all know, that is a very real situation given the fact that there's not enough testing. So a lot of medical providers are simply unable to give a diagnosis. And so the employee may be seeking the diagnosis, has symptoms, but obviously won't be a confirmed case. And so those are all triggers for this first part of the regular the paid sick leave. So they're entitled, your employees, your full-timers are entitled up to 80 hours. So there's an 80-hour cap. Your part-times, it's basically going to be a pro-rata. You're going to receive paid sick leave for the number of hours that on average they work. And there's a methodology going back and kind of looking how to conduct that on average. And so we do have part-time employees rather take a look at the DOL guidance on how you do that calculation. Paid sick leave ends when the reason ends. So if the shelter-in-place order goes away, or their medical doctor told them just to they'd already, for maybe whatever reason, they only needed to self-quarantine for a shorter period in time, 14 days. Whenever it ends, that's when the paid sick leave ends. This is very important. That the second to last bullet point. May not require your employee to use their PTO, sick leave, vacation, anything that they've already accrued. An employee may choose to do that, but you as the employer cannot force them to do it. The amount of the pay for these three reasons, the one that are on the sub-bullet points above, is capped at $511 a day, or for that 2-week period, a total of $5,110. So that's the paid sick leave that's for those three qualifying reasons. There's another form of paid sick leave for other qualifying reasons, but it's at a reduced rate. So this is for employees that are under these 4 triggers. So the paid sick leave is not 100% up to that cap of $511 a day. You pay it at 2/3 of the employer's regular rate. And again, the same caveat applies. They're only eligible if they cannot work or they cannot telework. The reasons for the 2/3 paid sick leave are as follows. And they're basically that the employee is not directly affected and it affects a family member. So if they're caring for an individual subject to a shelter-in-place or quarantine or isolation order, if they are caring for someone who has been advised by the health care provider to self-quarantine, if they are caring for a son or daughter, a school is closed, which is every school now, or their child care provider is unavailable due to COVID-19. And there's like a broad caveat based on if things may change and the employee is experiencing a substantially similar condition as specified by the Secretary of Health and Human Services. So this allowed the Department of Labor, if something unforeseeable happened that was COVID-19 related, the Secretary of Health and Human Services could then basically say, this is also going to be one of the covered provisions of paid sick leave. Much like the previous, basically was paid at a full amount. These employees are capped at 80 hours, and part-time, same thing, some sort of pro rata cap on their eligibility. The paid sick leave, just like the other 100% leaves whenever the reason for the leave ends. Same thing, employer cannot force employees to use accrued PTO, vacation, or sick. They may voluntarily. And the 2/3 rates is capped at $200 a day or $2,000 for the total 2-week period. So you basically have these qualifying events that are all COVID-19 related, 2 weeks of paid sick leave. And the question is going to be, is the triggering event one of those things that directly impacts the employee where they're paid the 100% up to the 511 cap a day, or is it one of these 2/3 regular rate provisions that allows them to get paid? So that's what the paid sick leave does. Here's a couple of questions that employers have asked that the Department of Labor has started to answer. Can an employee actually receive more than 80 hours by relying on different qualifying events? Initially, I'm because I can't work and it's a shelter-in-place order, and then I have a family member who's sick, and I basically get 160 hours. And the answer is no. Any kind of leave, even if it's for multiple reasons, is capped at 80 hours. Can the employer deny paid sick leave because it already gave paid sick leave before the act was effective? The answer is no. There is no offset for previously paid leave. It's, sort of the no good deed goes unpunished. The law is not retroactive. So, this benefit doesn't go back in the past. You can't get credit if you, out of the kindness of your heart, had already gave, paid leave. It's a new 80-hour cap, 2-week provision effective April 1st. You can, as an employer, require supporting documentation. And so that supporting documentation comes in quite a few different formats. So you can ask, if an employee is saying that a medical provider said I need to self-quarantine, then you basically can ask for, something, from the doctor. If you want some kind of proof, you're able to do that. So you don't just have to take an employee's word. Similar to the Family Medical Leave Act, you deal with that. You know that there's a right to ask for certain certifying information. And the details what you can ask for also in the Department of Labor guidance and the FAQs that are posted on its website under COVID-19. So there at least are some helpful things in terms of some of the additional guidance that has come out that I wanted to flag for you because we've been getting a lot of questions about this. As you saw, the trigger for being eligible is that the employee has to be unable to work, including telework. And so the DOL was asked, well, what does that mean? Because obviously you can imagine that there will be circumstances where the employer may feel that the employee can work telework, and the employee may feel that the employee can't. And so what the DOL said is, if you are unable to work, you're unable to work if your employer has work for you, and one of the COVID-19 qualified reasons set forth that we just talked about, those different triggers, prevents you from being able to perform work, either under normal circumstances at your normal work site or means of telework. And so basically, the issue is going to be, is the work available? The office may be closed if you're not an essential business. Do you have work that is available? And then it's going to be the employee's burden to say, well, I can't do that work because, and if telework is available, it's going to have to fall into something like, because I'm sick, because the doctor said, my condition is such, I can't really work, or because of the child care, I just don't have capacity, in my household, So there's a presumption basically that if the employer provides work and the employee is able to telework, then the employee should be teleworking, and then the employee, basically the burden shifts to the employee to say, well, here's why I can't. One of the things that you'll see here on this second bullet point is the DOL has said, if you and the employer agree that you will work a normal number of hours, but outside of your schedule, so that might be a way that the employer is trying to accommodate. So they say, look, you can do the work late at night or early in the morning, so that you can then take a break to take care of whatever COVID-19 related issues are affecting you. And the DOL said that that is one of those things where if you're able to work, then that's not going to prevent you from claiming you can't telework. So that there's flexibility here recognized by the Department of Labor. And then the second question is, and this comes right out of the guidance, is if I am or become unable to telework, am I entitled to paid sick leave or expanded Family Medical Leave Act or child care leave? And this is basically the same. The DOL says if the company lets you telework and you're able to perform certain tasks or work a certain number of hours from home or wherever your location is outside your normal workplace, and basically the burdens on the employee to show I can't perform those tasks, I can't perform that work because of one of those COVID-19 triggers, because of I'm caring for a sick family member, because I'm sick, one of those examples. So you'll see that one of the things that they specifically address in this bullet point below in the guidance, says, look, if you're unable to perform those tasks, teleworking work, because you need childcare, the school's out, childcare is not, childcare providers are not available, then you're entitled to take. That is a triggering reason, and you as the employee would be subject to the paid leave. So there's at least a little bit where the DOL has tried to expand and explain kind of how the analysis of whether someone can work or telework should be done. Okay, so that is paid sick leave. The other major aspect of this law, and really the last part of the new laws that we'll talk about, deals with this modification to the Family Medical Leave Act, the FMLA, for childcare. And you'll see how it kind of meshes and works with the paid sick leave that we just talked about, where employees are entitled to that 2/3 of their regular rate if they're having to take care of a child or have a child care situation. So under this child care FMLA provisions, eligible employees, and here's the trigger, they need to have worked for you for at least 30 days, are entitled up to 12 weeks of emergency family medical leave. And that 12 weeks is similar to regular FMLA if you've ever dealt with someone who takes leave in the past before the amendments to the FMLA. This emergency family medical leave may only be taken when an employee is unable to work or telework. So again, that's that threshold we keep seeing, very consistent with the paid sick leave. And the only trigger, this only expanded FMLA leave is this, because the employee must care for my child because the child's school or place of child care has been closed, or regular child care is unavailable due to the public health emergencies associated with COVID-19. So obviously, with schools closed and shelter in place, you have a lot of these triggers present for those who do have a minor child, and they're having to basically spend time caring for that child. Okay, so a couple of really important things to avoid some of the confusion here. This new FMLA leave applies to any employer with less than 500 employees. Now, that is different because all the other FMLA leave requires that an employee worked at one of your locations that has at least 50 employees, or they're employed within 75 miles, if you have multiple locations, or people that work in the field or drive or whatever. So this is different. So if you've never dealt with the FMLA because you have less than 50 employees, now you have to ask for this one provision, which is childcare. This does not expand the other triggers for Family Medical Leave Act, such as if you've had birth of a child, or you're taking care of yourself for a serious health condition, or taking care of a family member. It doesn't do that. It only expands it for this new group of any employer with less than 500 employees, just for this child care leave. So there's again been a lot of confusion about that. This new leave applies, as we noted, to short-term employees. Less than, they've had to have been there for at least 30 days. That's different than other FMLA. If you dealt with the Family Medical Leave Act, you know that employees are only eligible after they've worked for you for at least a year, 12 months, and they basically are working a full-time schedule, a minimum of 1,250 hours. So, this is a much more expansive version of the FMLA, but keep in mind, it only applies to this one new child care provision. And then as you'll see in the final bullet point here, unlike other FMLA, where an employee can take leave for serious health condition of an immediate family member, their spouse, their son, daughter, or their parent, this only applies to the employee. So, this is the employee is directly impacted and directly must take care of their minor child. It's not because someone else in the household needs to do that. So that's another important limitation on this new FMLA. Okay, so let's talk a little bit about how this works, and keep in mind this is paid. And so here's how, which is different. That's another big difference from Family Medical Leave Act for other reasons, because FMLA is normally unpaid. This child care leave is paid. Here's how it works. The first 10 days of this emergency family leave are unpaid, but the employee can use accrued PTO, paid sick leave, or the FFCRA, the qualifying COVID-19 paid leave that we just talked about, because that's, they get paid 2/3 of their income. So there's available paid leave for them as a matter of federal law, or for some reason not there, then they can use PTO or any other kind of sick leave that they've accrued. And much like what we talked about paid leave, it has to be the employee's choice. You cannot mandate that they burn their PTO. That's the employee's choice if they want to. But again, because you get the FFCRA, the paid sick leave, it seems like that's going to be what's going to make the first 10 days paid in any event. All right. The remaining emergency family leave must be paid at the familiar 2/3 rate that we saw in the 2 weeks of paid leave that we already discussed. So basically, they've got 12 weeks available to them, and that 12 weeks, the remaining amount after the first 10 days is paid at 2/3 of their regular rate. And you'll see a familiar cap on that next after this one. Part-time employees, they also get it, but they get it based on their number of hours of average. It's prorated, just like we saw with the paid sick leave. There is a cap. It's capped just like we saw under paid sick leave at $200 a day. And there's actually been some confusion because when the law was first announced, the Department of Labor said it's capped at a total of $10,000. But actually, if you do the math on it, the 12 weeks would actually be $12,000, and the recent DOL guidance is noted that. So it's a total cap of $12,000, but capped at $200 a day. Employees need to tell you, they can't just drop this on your lap and say, hey, I'm taking off. They need to give you some notice if it's practical. If there's a way for them to tell you, hey, my situation's got such that I now have to take care of my kid, and I just, I can no longer do any work. They at least need to give you some notice, some reasonable notice. This is important. Employees are entitled to job restoration at the end of the leave period. And that's consistent with the Family Medical Leave Act that says, hey, if somebody, who went out to take care of their own health condition and they were off for 6 weeks out of the 12, they're entitled to get their job back or an equivalent job, a job with equivalent pay and benefits. But there is an exception under this new form of child care law. That's for employers with fewer than 25 employees. You do not need to turn an employer returning from leave if that position no longer exists due to the economic conditions impacted on by COVID-19. And so if there is, an ability to say, look, we're just too small. We only have 10 employees. We're not going to be able in this position. We can't just keep it open. We've eliminated positions. Then you're able to rely on that exception, not have to restore the employee, provided two things. You make a reasonable effort to restore the employee to an equivalent position. So, hey, look, your job's no longer available. We don't need that because of COVID-19, the impact on our business. But here's a job, X that's, similar. That you have to at least try to provide that equivalent position. It may not be it. And then the other thing you have to do is make a reasonable effort for a 1-year period after to contact the employee if equivalent position becomes available. So keep that in mind. You may be the impact on COVID-19 when the person's ready to come back, and in May, you just can't, just not something you can do. But you need to, if conditions change and you make that position available again, you're going to post it. If it's within 1 year when the person basically is able to come back and you couldn't accommodate them, then you have an affirmative duty to reach out to them and say, hey, things have improved. This job is now available. And you have to offer them that position within that 1-year period. Okay, so on this revised FMLA for childcare, there's just a couple of things I wanted to end with on it, just to highlight. And the first is intermittent leave. And if you've ever dealt with the Family Medical Leave Act, you'll realize that there may be employees that need to take leave on small chunks of time. If they were under the standard FMLA, if someone needed to go, have treatments, 3 days a week, 2 hours, then they could get that time off on an intermittent basis. They didn't have to take all of the 12 weeks in just one big lump, or all 4 of 12 weeks, or whatever it may be. And the DOL just recently on its guidance said that it may be permissible for employee to work intermittently, meaning that they would be getting the paid sick leave or childcare leave under the FMLA for some other hours, and they'd be working for you and getting paid by the hour, or if they're exempt, you're getting an equivalent of their exempt pay. So that you could kind of patchwork this together and have some of it be regular paid work, some of it be paid leave work. But in essence, that's going to be your call as an employer. As you can see, the Department of Labor on this last bullet point encourages employers and employees to be flexible and really try to work on supportive agreements. But it's ultimately going to be the employer's call if that's going to be workable. And and maybe in some situations it's too hard to manage. But if the employee wants to try to work intermittently and get some of the paid leave while also working some, then you at least need to explore that. But ultimately, it's the employer's decision on that. And they emphasize this again, in terms of the stress that the childcare situation is going to cause on so many employees. Eminently, the answer is basically the same. That if because of the extreme conditions under the childcare FMLA provisions, if the employee says, look, there's some stuff I just have to do for my child, but then I can work other time. Can I take a mix of this leave? Again, it's going to be the employer's call, but the Department of Labor certainly encourages you to try to work with employees to be flexible, particularly given just how difficult everything is. All right, and here's very important for anyone who may be having the stress of having to go through a business closure on the effect of these laws. So if your business closes before or after the effective date, which is April 1st, 2020, of the FSCRA, employees are not eligible for any of the leave that we just talked about. Paid sick leave, expanded FMLA. If you're closed, then then there's no eligibility. And this includes closure because you simply have gone out of business, or because of a shelter-in-place directive. So that's really important, because if you are not an essential business and you've had to close, and you made that decision to close rather than furlough employees, et cetera, then employees are not eligible for either the paid sick leave or the enhanced FMLA. Now, the exception to this, obviously, you can see is if you are still working remotely, then that exception doesn't apply. I mean, if you're still working remotely, then the employees are eligible for their paid leave, childcare leave that we've discussed. And then the final point is, the same is true for furlough, as we discussed. If you furlough your employees, the employee is not eligible for either paid sick leave or expanded FMLA leave, but they are, and the DOL emphasizes this, eligible for unemployment. And obviously the CARES Act is beefed up and enhanced that unemployment benefit significantly. So, there's different strategies for a business who's looking at what should I do and how you can help employees. Can you survive it? Get a small business loan, keep the employees working, whether it's remotely or otherwise. Yeah, you might have some paid leave that you have to pay, but you're going to get a refund on that on your payroll taxes. So there's ways to kind of keep the business going with the different support we've talked about with CARES, and complying with the FFCRA on paid leave and childcare FMLA. Or there's these other options where it's we just need to go through a furlough and employees use unemployment, or we have to go through a full-on reduction in force layoff, potentially close the business. So there's a lot of different strategies, and I think these laws are trying to give employers as many options to stay afloat and to also help their employees who are going through extreme times. There is a notice that you need to be posting that is located on the DOL website. If you're subject to this law, it needs to be posted now. The law is about to be effective April 1st, and that's when you need to have the notice up. So it's time to get it. And obviously DOL guidance on this is they realize that most people post notices on bulletin boards in a break room, and they realize that that's not going to be happening. And so it's sufficient to email, distribute the notice to employees, or if employees are otherwise, getting information on an internet or wherever they may be checking in if they're working remotely, just as long as employees receive a copy of the notice some way, even if it's not the traditional posting of the notice. All right, so in terms of the tax credits, even though employers are having to fund this paid sick leave and they're having to fund this child care FMLA, covered employers will get reimbursed through tax credits on their payroll. And so, any of this paid sick leave or FMLA child care leave, the way it works is basically, when you deposit your what's called Form 941, when you basically show the taxes that are being paid in terms of the employee share of Social Security and Medicare, the employer share of that. When you show all that tax payment is subject to an offset based on what you've paid in paid sick leave, paid child care leave. And the best way to explain that is on this next slide and just show you the examples. So the guidance issued on this provides these pretty clear examples. If you as an eligible employer, for example, paid $5,000 in what we've been talking about, paid sick leave, child care FMLA, your payroll taxes are $8,000, then you could use up to the $5,000 you paid, so that the only part that you're making on your quarterly payroll tax is $3,000. So you're basically reducing your payroll tax obligation by the amount of money that you spent funding this paid sick and FMLA child care. The IRS says that there may be situations where the amount that you paid is greater than your payroll tax. And that's what the second example is. If that does happen, the IRS has said that they will accelerate a refund payment, that they expect to do that in 2 weeks. And we expect that there'll be some more information on how that will work on the IRS website. But as you can see in the example, you pay $10,000 in what we've been talking about, and you're required to pay $8,000 in taxes, then you also would need to make a request for credit for the remaining $2,000, or you can apply that to your next payroll tax. So effectively, that's how the Department of Labor envisions that even though employers will pay for this, they only really have to upfront the costs until they can get relief on their payroll obligations. So to the extent that that works for you, that's the way it's supposed to be structured. And if it doesn't work, then that's one of the ways that you can try to argue if you're under 50 employees that you should be exempt from this law because it will cause a hardship on your business. All right. And then a couple final slides, and I know we've got some questions. This law, the FFCRA, both the paid sick leave and the child care, has a non-discrimination, non-retaliation provision that almost every employment law has. So employees, if they're eligible, they're entitled to this leave. You cannot deny it. If someone asks for it, you can't retaliate. You can't discriminate, and there's some people leave and others not. So just a basic golden rule in terms of treating employees consistently and fairly applies with this law as it applies with really any employment law. There are penalties, and so you want to make sure that you don't get on the wrong side of the law here. If someone is eligible for this leave and you don't give it to them, then they can file a claim for the amount that they're owed, and they can also double that, just called liquidated damages. So there's a penalty structure there to encourage you to comply with the law, because if you don't, you actually pay double the amount that they're entitled. And because this is under the Fair Labor Standards Act, a federal wage and hour law, that means that if someone sues you, they could also collect attorney's fees. So you want to be very careful about that. Same thing for the enhanced child care leave. You're subject to penalties and liquidated damages if you don't pay the enhanced child care leave that we discussed. Now, one final bit of good news. There is a non-enforcement period for the first 30 days of this law. So basically, the entire month of April, the Department of Labor says that as long as you're acting reasonably and in good faith, you're doing your best to comply, and you're not trying to just ignore the law, refuse to follow it, then the Department of Labor, if they catch wind or there's some demand letter sent against you, you basically have 30 days in which you can remedy the issue, show the Department of Labor, look, we just delayed getting this going, but now we've got it. We've paid the employees what we owe them. So there's a 30-day grace period where the Department of Labor is going to try to work with employers rather than penalize them. So, I think that's always good news. Okay, so let me have a few other kind of other issue thoughts, but I think we probably had some questions. So if we want to stop and maybe handle questions that have come in, then if we have some time, we can cover some of these just kind of final high-level issues, if that works.
Thank you so much for your presentation, which was great. We do have some questions. We have one which is from Rick Jones, and he says, our company has most employees here, meaning in the States, but an office also in Norway. How does that affect our ability to qualify?
Okay, yeah. And so both of these laws pretty much are looking at your employee headcount within the U.S. So if it's helpful to exclude a foreign entity, then you obviously can, because they're looking at total employee population within the U.S. or any of the U.S. territories. And so, unfortunately, typically most of these are because it's favorable to be smaller, right? So that you're less than 500 employees. You cannot exclude, U.S. affiliates or related entities, but when you do have a foreign operation, you do not have to count the foreign operation, presuming that your U.S. entity, is incorporated in the U.S., is, a viable entity in the U.S., organized somewhere, and registered in some state in the United States, then you're just looking at your U.S. operation, including any affiliated operations where you're all part of one entity. So hopefully that answers that question.
Right. We have another question from Marlana. If you are a single member LLC, can you qualify for the child care credit?
Okay, yeah, great question in terms of single members. So, as you saw, the provisions in terms of one, any kind of eligible benefits for single member LLC in terms of even unemployment for the single member, those are allowed under the CARES Act. So you have your own personal potential benefit in terms of paying the tax credit. If you have the law in terms of childcare and providing the paid leave is also basically defined as to any entity that has less than 500 employees. So if you are a single member, then there's nothing under the law that would exclude you from potentially, obviously you have to provide yourself a benefit. But if you provide benefit under the law, there's nothing that we've seen, and obviously there could be new guidance changes that. But we haven't seen anything that would exclude, someone who's like a single member LLC or some other, single solo proprietor, independent contractor. The law appears to be pretty expansive to try to provide these benefits, and the argument would be, as long as you're providing to yourself, that you could apply for the credit, unless we see something different.
Great. I have another question. So he says, he's an anonymous attendee. He says that his son got hours cut in half, making it difficult to pay current bills. Still employed, but what assistance can he get?
Okay, yeah, that's a great question, because a lot of businesses have gone to the strategy of reducing hours, and it can be obviously difficult on any employee that has that happen to them. The legal issues are this: employers can reduce hours, and it's subject to a few things. One, obviously, you have to keep paying someone minimum wage if they're non-exempt, meaning that they're eligible for overtime and minimum. If the individual receives a salary, meaning that they're exempt under the wage and hour law from overtime, then you cannot reduce their hours below the federal guaranteed amount, which is $684 currently. An exempt employee has to make at least that in order for them to remain exempt and not to violate the federal wage and hour law, the Fair Labor Standards Act. So there are some limitations on doing that. Now, if someone has had their hours reduced, then in Texas, they are entitled to apply for overtime based on overtime for unemployment, uh, based on having suffered an employment loss. And that's where the Texas Workforce Commission has encouraged employers who reduce hours to work with the Texas Workforce Commission to set up what is called, a shared work program to do that. But the individual who's had a significant hours cut is one of the things that the CARES Act recognizes, that there are all kinds of things that could happen to people based on COVID-19, and so you certainly should explore applying for unemployment to try to offset the decrease, particularly given the fact that now there's going to be this $600 a week enhanced unemployment on top of what the person will be eligible for under state law.
Great, thank you so much. I had actually office hours with a previous company, and so that's a question he had for me, but I couldn't answer. So let's say, so he is a part-time, has a business, he has part-time contractors. Can those part-time contractors collect unemployment if they got their hours reduced? And if so, yeah, who files the claim? Either is it the owner of the company or the part-time contractors?
Okay, yeah, great question. Yeah, so previously, a contractor, part-time or full-time, would not be eligible for unemployment. The CARES Act changes that. And so just like, employees who have a reduction in hours are eligible for unemployment, the same would be true for contractors. And so the way it works is those individual contractors, they should apply for unemployment through the Texas Workforce Commission. And if you have any contractors or employees who are dealing with that, it's definitely takes a lot of time right now because the Texas Workforce Commission is just overwhelmed. I think, like most state agencies, they're trying to hire additional employees. So the recommendation for most people applying for unemployment is use the website, set an alarm for 3 a.m. and get up and apply, because during normal 8 to 6, 7 o'clock at night hours, the website's just getting crushed. And so the contractor should make the application, but just it's going to take some patience as the state unemployment agencies are just getting bombarded.
Awesome. Based on that question, the second question was, if that owner and those part-time, contractors do collect unemployment, is that going to affect the money he could receive from either the SBA or the PPP program?
Yeah. So another good question in terms of are you subject to any kind of reduction because unemployment has been paid under the PPP loan under CARES Act, and that would not be a provision where you would be subject to any kind of offset. So the way it would work is if individuals are obviously getting unemployment, like the part-time contractors, that's going to be certainly for their benefit. In order to if you've applied for a loan to manage your rents, your wage payments, et cetera, under the PPP, then obviously you still have to be committed to using that money for your workforce. So the fact that the individuals are unemployed could only hurt you in terms of loan forgiveness if you're not able to bring them back. So it's actually okay in scenarios under the PPP to apply for a loan, let some of the workforce go, reduce their hours, so you're reducing their pay. But by that June 30th deadline of 2020, you need to get back up to the level that you were at before that reduction to qualify for the loan forgiveness. So it only hurts you is if you can't bring, it only hurts you not that you won't get the loan, it hurts you on loan forgiveness if you can't bring up your employee hours and your employee headcount back to where it was, at the time that you got the loan, and it was keeping you at your levels that you were at before the COVID-19 reductions. So totally acceptable if you go out, they're taking unemployment, you've reduced their hours, et cetera. But when it comes time to show loan forgiveness, you have to ramp back up to your levels. Which, if you think about it, by the time you get the loan amount, hopefully, even if you had to try to stop the bleeding, by the time you get the loan amount, hopefully you're then able to, at least by that June 30th deadline, have hired back at full levels. So that's the only way it could hurt you, is on the loan forgiveness piece.
Perfect. Thank you. Any last questions? No, I guess not. Well, thank you so much for this awesome presentation. I believe one of the questions was, can we get a copy of the slides?
Oh, sure. Yeah.
So we can distribute to the attendings today. So we'll send an email with the slides from Matt. Thank you again. Remember that remember for all participants who attended today, don't hesitate to sign up for office hours to get one-on-one advice on the business. And if you have any particular questions that generator staff can answer. Also tomorrow you'll have another webinar focused on the SBA loan. So please make sure that you can attend that. Thank you again. I'll give a virtual round of applause to Matthew. And thank you for attending as well. Stay safe. And we will see everybody tomorrow. That's it for us. Thanks, everyone. Have a great end of the day.